Thank you to everyone that's attending. We are still getting people joining. Apparently our speakers today are in much want. I think we're up to about 40 people at the moment, although we had 90 booked on. But that's still good, that's amazing. We've got Stuart and Gemma from Nelsons Solicitors with us today talking about deputyships and when and how they could be contested. If you do have any questions, and Rosemary, I know you're out there, I know you've logged on, so please throw questions at me. We genuinely want them. If anyone else does have any questions, don't leave them till the end, jump in and ask us your questions, and we'll try to respond to them as soon as possible. For those that are on LinkedIn, I know you've all been very excited and most of you have logged on to see the chair. It's a very nice chair. It is the star of the show. I kind of feel like Graham Norton now. I'm just waiting for the chair to tip back and throw me over. I'm not doing that again, I'll brain myself. So we're going to start off with, like I said, a quick introduction from Gemma and Stuart, if you want to just tell everyone who you are. And
yeah, I'm Gemma Hopper, Legal Director and Solicitor at Nelsons, and I head up our court protection, non-contentious side of the team, so we do a lot of deputyship management. We also do PI trust and charity work.
And I'm Stuart, Solicitor at Nelsons, and I do the contentious court protection stuff. So if Gemma's doing something and it goes wrong or people start arguing, I get involved. And other stuff with family disputes between who's the right deputy, which we'll come on to today.
fabulous. So I know we were talking before this and we were saying that we have some people that join these videos that kind of have a little bit of an understanding of deputyships and LPAs and things like that. So can you just explain what is a deputy? Why would you need a deputy?
Yeah, so the deputies for property and financial affairs can be put in place when someone doesn't have mental capacity to manage their property and financial affairs, and probably more importantly, they don't have a lasting power of attorney in place. So unlike the lasting power of attorney process where the individual can select who they want to manage their affairs via the attorney appointment, the deputyship application gets made by the person who wants to be the deputy and who wants to be the person managing their finances, and then the court of protection, a judge at the court, will agree upon that appointment.
So am I right, you're a deputy for the court, aren't you? Not you're there to support the person, but you're the court's deputy, aren't you?
Yeah, the court of protection has chosen or agreed upon the application that's been put in place, and they make the final decision over who is the best person to be the deputy for that individual. So it's a best interest decision really made by a judge at the court of protection, and then once that authority is put in place, there's a court order that's produced that provides quite a lot of restrictions and conditions to that appointment that individual has to adhere to.
And I know you keep saying it's the court decides the person, but it can be a trust corporation as well, can't it, for finances?
Yes, so for a professional appointment like ourselves at Nelsons, we are appointed as a trust corporation, and that allows us to have a bit more flexibility really in terms of managing the person's affairs. It's not one named person, so we can have all the directors of the trust corporation are authorised to make decisions, and that helps when a professional is appointed, so that when it's a named person, if that person goes on holiday or they're sick or they're unwell, it can bring the management and the decision making to a close or to an end if they're not there to make those decisions.
I should say that's the ones that we've seen come through where specific solicitors or specific partners have been named on hundreds of deputyships applications potentially, and then they retire, and all of a sudden there isn't a professional deputy there, so then we're asked to go out to do the COP3s to reapply almost for the trust corporation that then comes in.
Absolutely.
So with the trust you get that continuation, don't you?
You do, and the way we do it at Nelsons is obviously people sometimes get a little bit nervous about an entity or a company being appointed, but the team sits underneath that, and we then appoint individuals to help the day-to-day running management. So you'll get allocated to myself or another colleague in the team who you will work with as a vulnerable adult, and we will build that relationship up on a one-to-one basis.
So I always try to see LPAs and deputies on scale, isn't it? You're independent with your finances at one end of the scale. With a deputy, realistically, you're supposed to be non-independent, you can't manage your finances, somebody else has been placed in charge of managing your finances. And then kind of in the middle sits that lasting power of attorney, doesn't it, where I've chosen somebody else, I've still got capacity to choose for this person to help me with my finances. And I know we make a big push on LinkedIn, especially, a lot of people push for LPAs to be put in place, but if you've got that lasting power of attorney, theoretically you should never need a deputy, should you?
That's right. If you've appointed the right person in the power of attorney, which I think is a really important discussion, when you're considering who you want to be your attorney, it should be someone who ideally is younger than you. Because a lot of the time people will appoint their spouse, same age, and as they get older, both of them really don't want to be managing their affairs. You can appoint a replacement attorney, which is ever so helpful. You can also appoint a professional under a power of attorney as well. So it's about picking the right person, because the attorney does have an awful lot of authority in that managing of the affairs, and you want to ensure it's the right person who's going to work with you still to manage your affairs when you can no longer do that yourself. But yeah, absolutely, once the power of attorney is in place, if you've got the first tier appointment and a replacement appointment, really you should never need the court protection to become involved.
No, because you've already chosen, you're securing that, haven't you? We're looking at deputyships when they're contested. So who can contest a deputyship?
Well, normally it's anyone that's sort of notified of the application, so close family members really should be notified, or the applicant, which creates loads of issues if the applicant themselves contests it, because they'll get served a copy of the application and they may say, hang on a minute, I've got capacity, why is this being done? That's less common, it's more likely family members or anyone else that may be involved in providing care if they are notified of the application. I suppose
that makes sense, really, that, you know, if not, I could apply for a deputyship for Gemma. If she's not notified and she can't complain about it, then, you know, then theoretically I could end up deputy and you're sat there on a Wednesday afternoon going, what's going on? So it makes sense that, and we see people where family especially think that mum's lost capacity, and then we go out and there's nothing, they're perfectly fine. Or they lack skills and knowledge around finances. So yeah, it makes sense that the P, the individual, is the first person that can contest it. So they can contest it. Anyone else that's notified. So that's family and friends.
Yeah, and close people who are involved in their care. So
would the local authority be included in that?
Sometimes, if the local authority are involved in providing care for P or somehow involved, then they may be notified. So normally, whoever makes the application lists who's going to be notified. And the court, they like to see sort of at least 3 people being notified. And they're also alive to who else could be notified. So we've had it on a few cases where people have applied to be deputy. The court said, well, why have you not notified sister? And then the court will say, we're happy to deal with the application, but first go ahead and notify sister, for example. Let's see what she has to say.
Because you don't know that sister or brother might have fallen out, or brother might be the abuser in a case or something. And if he's not told you about sister, I suppose
that's it.
And you as solicitors, you're the same as us. You can only go on the information that's available to you. If somebody's hiding information from you, there's not much that you can do, is there?
And we always quite like there to be an independent element to the notification process, which isn't in the deputyship application, isn't strictly necessary. If there isn't a social worker, for example, involved, we do tend to notify them as well, to give them the option to, you know, say, well, actually this person isn't the right person, and to say why. But again, it's just finding the right people to notify, and it should be really the closest people involved.
I was going to say, we do come across that where the local authority will contact us and say, no, you've just gone out to complete a COP3 form for the son. We disagree with this person being appointed. I'm like, well, that's fine, but that's not it's not up to us to decide that sort of thing. You need to go to the courts. I don't know whether they do end up going to the courts, because we're in that side of the process where we don't always get to hear the outcomes, sort of thing. But yeah, we come across it where local authorities, they know something that maybe potentially the rest of us aren't aware of. So family P, the person themselves, and local authorities assume that counts NHS as well if the person's on a hospital ward or something like that.
Yeah.
Potentially care homes.
Yeah, if they're in a
Yeah.
care home, that's always a good person to always include to notify
Yeah.
if it's sort of an elderly person in a care home. Sometimes we see it, sadly, when I've not got many family members or friends they can notify, so you're struggling to get to the free.
Yeah.
So people at the care
I
home.
must admit, we have been added onto that list of people to notify occasionally,
Yeah.
because I think that the solicitors have struggled with that through, and at least we have had face-to-face, contact with that person, and potentially the proposed deputy as well. Yeah.
We always encourage the family to have open and frank conversations before the application is really made.
Yeah.
So there is a discussion had between the family as to who is the right person, and we do tend to encourage, if it's going to be a lay deputyship appointment, that it is more than one on a joint and several basis. And again, that stops any problems should someone go on holiday or someone be unwell.
Yeah.
You can have two people in the family to work together, but as long as that's going to
So like a lasting power of attorney, where you can
Absolutely.
choose more than one attorney,
Yeah.
you can have more than one deputy, which we do. I'll be honest, we don't see all that often. We generally see one person. If it's families, we might see two, but generally a lot of the applications we see on coming through for us, it's one named person.
Yeah, we tend to find sometimes when we're having these conversations before we've even made the application to try and ensure it's not going to be objected, because we'll move on to Stuart in the terms of the cost that can incur.
Yeah.
When it does become disputed is quite high. So we do try and get them to have those conversations, and a lot of the times it's drilled down to their fear of just one person being in control.
Yeah.
And then, understanding that there can be a joint and several appointment with two family members can alleviate some of that pressure. But when we do pick up on,
And surely, if you've got brother and sister, that takes off the pressure of sister doing it by herself. You've got the reduced pressure of the brother thinking something's going on, because regardless of how good you are, how close you are, you kind of have those. Hang on a minute, what is going on with mum's money? Where is it going?
yeah.
And as soon as that enters somebody's head, it's just going to get worse and worse.
And we do reassure families that even if a family member is appointed or a professional, we all have to report annually to the Office of the Public Guardian. So every year we've got to account to the Office of the Public Guardian for all the income coming in and all the expenditure going out, and justify
Yeah.
the decisions that we've made. And again, sometimes the family just having an understanding of that can alleviate some of their concerns as well.
Oh, we've had a question. Ria. Sorry, I'm reading. In this,
If B does not have,
second, sorry.
if B does not have 3 people to notify,
Yeah. So if P does not have 3 people to notify, what do you do in this instance? What if there's only 2 people, a care home and me?
Yeah. I mean, we tend to, a lot of the times we say we're going to have to find 3, or the court's going to have a problem with this application, and we'll have to add in a justification of not notifying 3 people, and request for permission for that to be dispensed
So
of.
being a little bit imaginative almost.
Yes, and when you start to ask the question, there tends to be a next door neighbour,
Yeah.
there tends to be friends. You can widen the scope of the notification. We tend to be able to find 3 by the time we've done a bit of digging around. Worst case scenario, the court could order us to do a family tree independently, and to really search for those lost relatives so that we notify them of what's going on. But it would be an additional step to the deputyship application that would make it a lot more complicated than the straightforward deputyship applications that we see going in. If we can't fill those 3 people, we have to inform the court formally that we're unable to do so, and provide evidence as to why, and to why not notifying people is in P's best interest.
I mean, to be fair, just off, if somebody like us, like me, will have to have done a capacity assessment, that's one person to notify. If they're in a care home, then if they lack capacity, they in all likelihood will have some care around. So there's a domiciliary care manager or residential care manager.
We have notified GP before,
Yeah.
because the GP's been involved, and like I said, social worker. who's been involved, especially if they've gone into a care home. There's probably been a social worker appointed to make that decision. There'll be a DOLS process potentially that's going through or gone through. So
unless you're contesting the application, you don't actually, as a notified person, I don't actually have to do anything. It's just
Correct.
you guys have to notify me. I get a nice form come through, and if I want to object, I can.
yes.
So realistically, the local authority social worker receiving one, a care home manager receiving one, and a capacity assessor receiving one. That's your three, isn't it?
Absolutely. And we do say to people, look, if you're happy with this appointment, you don't need to do anything, but take time to read over the paperwork and what's being asked of the court, because if you feel like it's the wrong person being appointed and you've got evidence to support that it's not in P's best interest for this to be done, you should object. But you're quite right in the sense that the majority of people that receive the notification, you don't have to actually do anything with it if you're happy.
And if there is nobody else, they're the people that know that person closest, even though it's not that close, I suppose. So in this case, P only has a dear friend and does not have family. Would you just let this in the application? Would you just put this in the application? I think we've kind of answered that. No, you wouldn't. And you'd contact the carers, the nurses, anyone else that's involved.
I mean, the best friend is still one.
Yeah.
So really, you only have to find another two, potentially a neighbour or a care home if she's in a care home,
Or
social
domiciliary
worker,
care, or
absolutely, care agency, whatever might be assisting her.
I mean, I'll be honest. If somebody's got to the point where they're having a deputy put in place and there isn't care in place, I'd be querying why there isn't care in place.
Yeah.
Because there should be, in all likelihood, there's going to be further involvement. And if there isn't, why not? In that case, you could see the friend being burnt out if that friend is providing all care, and we do see that. Another one. Marina, is the webinar only for elderly, or is it going to cover special needs children, although they are now adults living at home? That's a really good one, actually. I was talking to you earlier, actually. I went to see somebody with cerebral palsy this week. That's being discharged, non-contentiously, I'm afraid, Stuart. It's all nice.
Everyone's happy.
Everyone's happy. Even the deputy is happy about it. But obviously, you know, a large proportion of clients are acquired brain injury, children with special educational needs are now adults with special educational needs, and we come across those where they've been assumed to lack capacity until they're 18, and the assessments identify that in all likelihood they won't have capacity when they get to 18, and then they turn 18 and they're fine. Or they believe that they're fine, they believe that they can manage their own finances. Have you worked cases like that?
We do have a lot of ABI clients, acquired brain injury clients, from large settlements that have been awarded, and a lot of the time that is medical negligence from an injury at birth, unfortunately, and we are there to help the family, and we do get appointed when they are minors to help manage the settlement funds. And when they obtain the age of 18, as you know, there's a huge shift in all the care and everything surrounding that, and we have good case managers and yourselves who can go out and assess, and we do also reconsider the position of the deputy as to how involved we are now with the now adult, and how we change our approach with them, and how much capacity they have in terms of managing their affairs, and whether they can manage their day-to-day spending and should be given more autonomy. We're certainly there to support that, and we will reconsider our appointment if that's in their best interest to do so. And the only way to look at it is to get them reassessed, and we will look to reassess them at that point. If they are managing their funds well, if they're dealing with their own bank accounts, a lot of our clients do on a day-to-day basis, absolutely fine. We support them, we get requests directly from them for funding for holidays, additional money for whatever that might be. They're very much involved in picking their own wheelchairs and dealing with that kind of aspect, and we will fully support that. If there is a change in mental capacity, which can happen, people can regain mental capacity at any point, we will reassess and we'll have to get ourselves discharged if that is the position that comes out, that they have mental capacity. We will apply for our own discharge, and we would advise the client at that point, especially if there's personal injury funds and a settlement, to set up a trust.
Yeah.
So it would be transferred then. I think that's a completely different
Yeah.
webinar to look at that a little bit more closely, but overall it's quite complex, but that is the position we'd be in, and a lot of the times we end up being a professional trustee and helping them via just a different legal vehicle really to manage their funds, but it's a very similar
I think
setup.
I mean, one of the cases that I talked to our new social workers when they started, so I went to see a young man who'd been in a car accident when he was 4 or 5 years old. I'd been identified at that age that he'd never have capacity to manage his finances, and his mum got me out on his 18th birthday. What a rubbish birthday present!
Oh.
Can you imagine? But genuinely, it was on his 18th birthday, and he'd got several £1 million in compensation. And this young man sat and talked to me. They were trying to get the deputy discharged. The deputy was quite aggressive that he didn't have capacity. He managed his day-to-day, his day-to-day finances for any small mobile phone bill and things like that. But he sat and he was talking to me about his investments and how he wanted to invest in the S&P 500 because it had been going for 100 years and it hadn't lost at any point in those years, even though it was a low-risk investment and low-return investment. And whether he was right or wrong, the fact that he'd done his research was impressive. And then he started talking to me about that without any input, talking to me about lasting power of attorney and how he should have his mum as his attorney in case anything happens to him again in the future. He talked about cars and that he could afford a Ferrari, but he'd only get a Volkswagen Golf because he knew that it was his first car and he'd probably hit it and bang it up. And you just sat there going, well, actually, at 4 years old, and you could identify that there was some learning disabilities, there was some special educational needs, but you couldn't say that he lacked the capacity to appoint an LPA or to manage his own finances. He knew the importance of having a financial advisor and things like that. He got all of it. So we see quite often these young children, whether they've had medical negligence, acquired brain injuries through car accidents, things like that. And the assumption that they have to make is that they won't have capacity. And then they get to 18 and they're brilliant, they're amazing. What have you worked? Have you got examples where those things like that have had to be contested and family are quite? Because I've seen that where family can be quite assertive that they now want to take charge of the person's finances. Maybe that they think that son hasn't got capacity, but now there's millions of pounds in the bank. I want to be the deputy. I think it'd be better if I, as mum or dad or whoever, would be deputy.
Yes, you see that quite a lot. One similar example would be, I had a chap approach me who had been in a motorbike accident, I believe. So he had temporarily lost capacity. For a few years, I think it took him to recover, and the deputy was appointed. And this deputy didn't seem like they were doing a good job. They just left him to it, gave him his monthly allowance, and he rang up and said that I've got capacity now, I think. I want to be in charge of my own money. I don't see why I need this deputy. I need to ring up every time I need £100. And the key was get a capacity assessment. If it proves you have capacity, then you've got to speak to the deputy, say, look, I've had my own assessment done. Because the deputy wouldn't let an assessment take place. So I said, you have to try and fund it yourself, ask for money. Got his capacity assessed, and then the deputy still wouldn't agree, so he had to get help from possibly the official solicitor to make his own application. So,
Is there no safeguards there? So realistically, if he hasn't got, if he's only been given £200 or £300 a week, he's having to save up from that and pay his day-to-day bills, to then save up to pay for a private assessment, to then save up to pay for private solicitors, even though he's got potentially millions in the bank and he's got a deputy, but the deputy is just going, well, no, go away.
it can be a bit of a catch-22 at some point. So the deputy's not going to agree, so we could help him and represent him and say that we represent him, but technically he might not have capacity to litigate. so he might not be able to instruct us.
So then
in
he
the
could
first
end up
instance.
trapped in a situation where he's got a deputy that isn't
Potentially, yes.
isn't a positive. I don't want to say a bad deputy because you don't know the entire situations in
Yeah.
those stories. But it's not a positive deputy. They're not having a positive impact on his life, are they? They're not helping him to grow and develop.
So I don't think normal. I know Gemma's team, they go out and visit their clients every single year. It sounds as though that wasn't happening, so it looked as though he'd just been appointed and sort of gone, here, this is what.
I'll make sure your direct debits are paid and I'll leave you to it.
Potentially that was enough straight away in the first instance, but as I say, as things moved on, as he recovered.
And that's the thing with acquired brain injury, with special educational needs, people do grow, they do develop, they do change, their capacity changes, and the way they learn changes as well. I can remember a elderly client, she was in a wheelchair, she was a wheelchair user, he had dementia. And you looked at this couple on paper and it was like, they couldn't go shopping, they couldn't do this, there was nothing that they were able to do. Before I walked into their house, we're probably going to end up looking at care home. Maybe we'll get away with domiciliary care, maybe. I walked out with giving them a lifeline alarm system because between them, they'd just figured out how to get everything to work the way they needed it to do. And it was really ingenious things, like they'd bought a tiny little camper van because it had a toilet in it, and when they went to the shops he needed the toilet quite often, so instead of trying to go to a shop that had a toilet in, they just went, well, we'll go and buy a camper van and I can drive it and we'll have it modified. And, yeah, exactly. But people do that, don't they? And they find ways around their inability to complete a task. They'll find a way to adjust to that and find a way to complete that task. And deputies should be promoting.
It's part of what we really do strive to do within our team, in the sense of our approach to all of our clients is very different, and we've got quite a big team, so we're lucky in the sense that once we get to know the client, we also appoint who we feel is the best person to be that liaison for our team as well. So it's a very tailored approach, but it's hard when you hear about a deputyship not going well, especially when it is a professional appointment, but it can happen. But if P does regain capacity, it's about supporting them to get their autonomy back. And if anybody's listening to this, or anybody comes across someone who they are concerned about acting in their role as deputy, the Office of the Public Guardian supervises and investigates all deputyship appointments, and that includes professionals. So at times, we've had family members argue with us in terms of how we're acting, and I will say to them, well, you can report me to the Office of the Public Guardian and they can independently investigate what we've done. And that does reassure a lot of family, it does reassure a lot of social workers who were involved. It's kind of saying, well, and we get a lot of inquiries ourselves, this relationship isn't working, and whatever those reasons might be, it's either for us all to work together and find the right appointment for that individual, or the OPG can look to really investigate that and look as to what is the root of the problem. It might be the deputy, it could be the vulnerable adult. It's difficult and is causing problems, and that relationship has naturally broken down, and they no longer want to work with the professionals involved, and that can happen with social workers, medical professionals, legal professionals, and we see it quite.
I mean, we have in occasions where we've gone out, we've done an assessment, and the family aren't happy with the outcome, and they scream and shout, and it becomes very talk between us, because we're saying, well, actually the outcome's the outcome. There's nothing that we can do about that. I'm very sorry, but your mum lacks capacity, and they're not happy with it. And then they want another assessment, and we're kind of, well, actually, no, because the relationship's broken down, and we're not going to get the best out of the client anymore, because you're going to be standing in the room fuming at us. So I mean, that breakdown of the relationship can happen with anyone at any point, can't it?
Absolutely.
I think that one of the things when we're talking about special educational needs and acquired brain injury, and that progress that people make and the changes that they make, we often see it where clients, we're assessing them because they feel they've regained capacity and they haven't. So we have to be really therapeutic in our approach to the assessment. I'm sure you come across this all the time, Stuart, where people are ringing Gemma up and screaming that I've regained capacity, you're holding me hostage, you're only doing this because you're earning money from me, and all of those things. How do you manage those? Because 6 months later they're then ringing up again saying, okay, I've had an assessment but I think I've regained it now. And it's a continuous story with them, isn't it? And they're not regaining capacity.
Yeah, I mean, we have seen somewhere they'll get a capacity assessment, for example, they'd use yourself, you say no, they say, right, I'll go to somewhere else,
yeah.
Keep going. But essentially what we have to say is, if you've not got capacity at the time, let's look at what's not working for you. So, you don't like this deputy because of X, Y, Z. Well, is that enough to say, maybe that deputy is not suitable, let's see if we can help you. Probably have a family member supporting them who will probably give us the instructions to say, let's get another deputy appointed. And there can be loads of reasons. A common one is sometimes the panel deputies appointed, unfortunately they're not always local. So you could say, well, this deputy's he's not here when I need him, so I'd like a more local deputy, and you have to apply to the Court of Protection for it.
And that's geography, isn't it? Because we see that where people in Lincolnshire are deputies for people in Southampton. However, sometimes it's because they're a panel deputy and things like that. But sometimes it's just the family member lives in Lincolnshire and they've contacted their local solicitor, who's then put in the application, and then they have contact once a year maybe with their client.
So with several reasons, not always just locality. Could be that there is just, let's say, a simple breakdown in relationship. And you'd hope any deputy you approach say that there's been a breakdown in relationship between you and P. P would like to have you removed, as long as you put forward a suitable alternative. I hope the deputy does agree.
We've got more questions for you. Rosemary, I knew you were going to jump in, Rosemary, thank you. I've been waiting. How is the firm of solicitors paid for this work, and are there standard fees?
So the deputyship application and our management fees are all under the court rules. So there's a specific practice direction that authorises the type of fees we're allowed to charge. Some of the work is fixed fee, so we're not allowed to charge any more than what the practice direction says.
There's a difference between the fees for a professional solicitor's deputy and local authority deputies.
Yes, there is.
And lay deputies.
Yes, there is.
You can't charge the same, can you?
That's right. So local authorities, when they're appointment, they have set fees that they're allowed to charge for. The professional deputyship, when we're appointed, it's quite a complex assessment process that we have to go through, and we have to adhere to the court rules in terms of what we're allowed to charge. But overall, through an annual period, our entire file is assessed independently by the Senior Courts Costs Office, and they authorise us, they allow us to charge a fee for that work. So that's why it's really important that a deputyship team has different people who are working at different grades and are working at different levels and hourly rates. And our hourly rates are fixed by the court as well. So our hourly rates are a lot lower in court protection work than it will be for other private hourly rates.
That depends on your role as well, doesn't it? Because there's junior grade solicitor as such, even though they're not the deputy, if they're working on, or a paralegal if they're working on the case,
absolutely,
their rate's different to what the partner's rate would be. So
I've got a fantastic team who work at all the different levels and grades. We've got apprentice paralegals, apprentice solicitors.
Yes, I've seen that.
We've got associates, solicitors and silex, and a senior associate as well, and all the work is graded down into where it should sit. So that makes it much more fairer for the vulnerable adult. It makes sure that the right charges are paid.
There's been cases as well, and I'm no expert on costs, scores, cheese. I'd leave that to Paramount. But there's been cases where partners have done work that should or could be completed by paralegals, but charged their rate, and the cost courts have kind of gone, no, actually, you're not allowed to do that.
There's been a lot of firms, I think, that have been burnt in the past, and there's a lot of good firms with established deputyship teams out there who are fully aware that I can't pay a bill, I can't pay an invoice, I can't send out generic emails, I can't send out pretty standard letters. it all has to be done by a lower grade member
Yeah.
of the team, and that's in P's best interest.
Yeah.
That's not to say that I don't want to do the
No,
work.
you don't need a partner,
but yeah,
a director to be sending
absolutely.
out simple letters and things like
We
that.
need to be doing more of the high end best interest making decisions. I do meet with the vulnerable adults, I do meet with the clients, get to know them, but then a lot of the work that follows on from any decision that I make or any outcome that may come from a different type of application, a lot of the work is done by more junior grades within the team, and that's a good way for them to learn and develop, you know, to get that knowledge and understanding of how that thought process and those best interest decisions are made, but it also ensures, more importantly, that the P isn't getting charged out at significantly higher rates when the work should and will be done by junior grades.
This idea and this complaint we hear all the time when we're assessing for deputyship, leaving the court protection, is my solicitor charges me a fortune. They charge me for absolutely everything. If they have a cup of coffee on the way here, they'll charge me for that. And all of these sort of that's not quite true, is it? Because the accounts are being independently reviewed. So if anything like that was put on there, it'd be pulled out.
Yes.
And then the courts are actually checking and agreeing this as well. So if you were putting in, I stopped at Costa for an hour, and I'll bill that at 6 minutes a time, and I'll charge for my double latte as well. They're going to be asking questions of you as a firm.
Yeah, absolutely. I mean, there's so many reasons why that wouldn't be done, but more importantly is because, you know, the independent assessment that takes place, our files are independently assessed by a legal costs officer in the first instance, so like Paramount, as you mentioned, and then it goes to the senior courts cost office, who again very independent, and they review the file and agree what we're allowed to charge, and they love their red pen. They
I've got
will,
a new job for Kerry.
they will cross out everything and anything, and they are really there to, you know, as a benchmark for it.
So Rosemary's followed up with this. Where does the money come from to pay the ongoing deputyship held by the firm of solicitors?
No.
So the money, our fees are paid by P. They are paid by the vulnerable adult who we act for, as would any solicitor. If you instruct a solicitor, you would pay our fees. The reason why they're independently assessed is because usually that vulnerable adult can't agree our costs. So I can't have that conversation with my client. So it's independently assessed, but inevitably the funds are used to pay for our bills.
So is there a because obviously if I've only got £15,000 in the bank and I don't own my own house and I've got that's it.
Yeah.
Is there a limit that the courts say actually you don't need there's no point in you having a deputy?
It has to be proportionate for us to take on an appointment in a professional capacity, and the court is aware of that, which is why really they do prefer to appoint a family member, because there are no management costs. There'll be the security bond and the supervision fee for any deputy appointed, but the ongoing costs don't exist because a lay deputy can't charge for their work like a professional can. And similarly, when we're approached to take on an appointment, we are quite open and honest in that we do charge, and we have to ensure that that's proportionate to P's estate, so we won't take on appointments.
The local authority take on deputyship role as well, don't they?
Yeah.
And I know we see these coming through quite often as well, where P's got over a certain limit, the local authority are kind of going, actually our insurances and our processes can't manage this anymore. We've handed this over to Nelsons, to Chatham's, to whoever, you know, generally I think they have partners that they work with, don't they? And they'll pass it over to their solicitor to become the attorney. So they'll work for either less or
if there is
at the end
still,
of the day they've got a legal responsibility to provide support.
that's right. If there is a need for a deputyship appointment, the local authority can take it on. Most local authorities will do for lower estates. If we are appointed as a professional, you know, we will do our due diligence to ensure that it's right for that individual to take on the appointment. And we've had referrals come from local authorities where, you know, they found correspondence in P's home, for example, from Nelsons Solicitors. They could see that they've done their will with us, for example, or they might have done other work with us in the past. So they will approach us to look at taking on that appointment because the individual's our client and has been in the past. So we're quite happy to look into that. But yeah, it is the court's decision. The court will make the final decision. So one way or another, if there is a deputy needed, there will be one found to be appointed.
Yeah. Ria. Okay. How?
Ooh, do you see
This
one?
is a good one. How does the court check to see whether the deputy applying is the right person? As it is the deputy themselves that are informing the solicitor of the people to notify and the family relations, and therefore, technically speaking, could the potential deputy be able to admit the people that may object to the application? So yeah, you've got an abuser. Let's make it simple. You've got an abuser coming to you saying, "Oh, my mum needs a deputy," and when you say, "Who do we notify?" he says, "Oh, there isn't any. Don't talk to my sister that you don't know about. Don't talk to my dad that you don't know about." Or how do the courts identify?
That's always a risk. It kind of comes back to what I said earlier, is the court do scrutinise the applications quite closely, and they'll look through. So normally you may submit a witness statement with your application, and there's loads of just generic information you have to fill in, so relationships, P have a will. So they'll look at all this information and think, oh, is there someone else that could be notified? Or there may be some indication that maybe they do have family members, and they will then say that they're proactive and say, you need to notify this person. But if it does sort of slip through the net and they get away with it and they've not notified who should have been notified, then they could be appointed. However, then hopefully that person finds out, and then they can have to bring their own application status.
So there isn't a check, realistically. There isn't the courts aren't going to sit there and go, okay, we've got Mrs. Smith, let's do a genogram and find out who her, or start searching the censuses, or speaking to Finders International and people like that to get those family trees done. But then I suppose even if you did, what if it's the next door neighbour that's the best friend that knows they're abusing it?
I guess you then hope that, as Gemma mentioned, you then have to report every single year where every penny has gone. So you then hope that if they are abusing them and all of a sudden there's loads of money missing, you'd hope the OPG say, oh, actually something's not right.
It's quite strange, let's be honest, it's quite strange the amount of people that apply for deputyship going, great, I'm going to get all my mum's money, and then try to do that as well.
Yeah.
It amazes me when we get abusers ringing up, trying to do everything the right way. And part of my brain sat there going, why are you getting more people involved? Because this is happening. We've identified that you're not right to be an attorney or a deputy, because you're ringing up telling us, once I'm the attorney, I'm going to sell one's house to pay for my house, or and they're really quite obvious with it. And as an attorney, you've got no checks every year. As a deputy, you have got those annual checks, so you're going to get caught. But they seem. A police officer once said to me that we only catch the stupid criminals. It's a little bit of that, isn't it?
And you've got to remember with the deputyship, sometimes people actually quite like the additional safeguards in terms of the reporting to the OPG every year. You've also got, you sign a declaration to the court to say that you're going to be on your best behaviour, and that's quite a lengthy form that you're declaring that you're going to do everything above board, that you're going to adhere to the legislation, and that you're going to report to the OPG. And then added on to that, there's a surety bond that's put in place, which is a bit like an insurance policy. It's the easiest way to explain it, and that's a fixed amount put on by the court, which is the value of the estate of P 9 times out of 10, and that ensures for if there is financial abuse done by the deputy, that anybody else who's appointed can call that in against them personally.
So they can claim that money back from the deputy.
Yeah.
A few times,
We've done that a few times.
If I don't know, if I was appointed for my dad, and I would never do this, it's lovely, and I rob him blind, and I take it for everything he's got, sort of thing. Could I potentially be looking at prison sentences and things like this? What's happened in the cases where?
Ones I've seen and dealt with, the bond obviously pays your dad back what you've taken, and then the bond provider will then pursue you for the debt. So say it was 500,000 you've taken.
And that's when I get the bounty hunt that's chasing me down.
That's it. So worst case, you can see bankruptcy.
So it's literally like a bond, like in the US. So you've got bonds companies that
Yeah.
pay that money back
Yeah.
and then chase me down,
That's right.
because then that
Sure.
debt becomes mine.
And that's personal to you.
Realise.
And we have, well, we've heard on the grapevine, obviously, that it's left left people bankrupt
Yeah,
or having to sell their home because they don't have the cash available anymore that they've taken.
no, because
Because they've spent it.
yeah,
So
they've been to Las Vegas
yeah,
for 2
the
weeks.
bond
haven't they?
provider has a lot of push to get
Yeah.
that back from you, and that's an agreement you've entered into.
So even though
with the
those
bond
checks
provider.
aren't there, there's safeguards there to make sure that if that abuse happens,
Yeah.
it's
And
fairly.
the terms of the bond can be quite sort of strict as well. I've seen some sad cases where family's been acting as deputy. They've made a decision they thought was in P's best interest, so they've invested in something risky. They haven't taken professional advice, which is probably the key mistake. They've lost money in this investment because it turned out to be too risky or potentially a scam. The bond providers then pursued them because they paid P back, and they've ended up bankrupt for what they
Because the
thought.
risk was too high, essentially, and
Yeah.
that wasn't in P's best interest.
But they
Investing would
thought
have
it
been,
was.
just not.
Yeah, just not in
Yeah.
that.
Yeah.
So it's, the bond is, the terms are really strict, so that's something to be careful of.
Yeah. Yeah, I genuinely hadn't realised that that's how the bonds work.
And that's in every court-appointed deputy,
Yeah.
professional or lay. It's always put in.
So
place.
again, that puts down that idea of the solicitors, the professional deputies going off and just spending my money on holidays and coffees.
Yeah.
Coffee seems to be the big thing I hear.
Never
I'll be
charge the
honest.
client for a coffee.
No, I don't know how your brain would work. All right, I've got the receipt. I'm nowhere near my client.
I mean, I
In fact,
drink a lot of coffee. It
I'm,
might not be.
I'm 2 hours away from my client, but I'll charge them for it
Oh,
anyway.
no.
I don't. But if they did, that could ruin a practice.
Yes, I mean, I've previously worked for the Office of the Public Guardian, as you know, as an in-house government lawyer, and we did a lot of the investigation, and one of the biggest investigations I was involved with was with a professional deputy, and the SRA was involved, and it was very messy.
Yeah.
And again, it is because we're at a higher level, well, a higher standard is
Yeah.
expected, as it should be. Our integrity and everything is overseen not only by the court protection, but by the SRA independently as well, and you know that hopefully stops there being any sort of concerns for the family, and some family have approached us and said, no, we want you to be appointed, you know, we don't want to have this responsibility.
Yeah, no, you've said
yeah.
it. I can't blame them. I'll be honest, I don't.
We've
I don't
looked
want it.
into it, we
Yeah.
don't want to do it, will you please take it on?
just
And, you know,
shows
it's
the
fine.
importance of getting that lasting power of attorney done whilst you've got
Yeah.
capacity.
Yeah.
Because it's not only I've made my own choice about if I become ill, who I want to manage my finances, but you're also stopping the risk on your family of, like you said, you know, my son, when I'm 60, decides actually I'm going to put all this money that Dad's made over from Nellie supports, billions and billions, into Tesla, because, you know, Tesla's doing really well, and then it drops out, and all of a sudden he's being chased. I wouldn't want to put that pressure onto him, or that risk onto him, that, you know, he has to be my deputy and he could lose the living the livelihood that he's made for himself. As an attorney, yeah, if he goes out and steals my money, then he's going to get into trouble for it, but the pressures aren't quite there with bonds and things like that, are they?
Yeah, and really with the power of attorney, again, it's about you making the right decision.
Yeah.
So it's not always a family member who you should appoint. It might be, you know, your friend. It could be a bit more of a distant relative, not necessarily your children, because you might not want them to do that for
Yeah.
you, and they might not be the right people to do that for various reasons. Maybe they have their own mental health problems.
I've got a
or
16-year-old
addictions
daughter.
and-
She would never be my attorney at the moment. She'd just take my credit card and be off.
Oh, yeah. Yeah, they could be too young. So you should always have a power of attorney in place that reflects the right person now to
Yeah.
take it on, should that be the need. And, you know, we do have some appointments through powers of attorney that our clients have decided to pick the trust corporation because there isn't any family members.
That stability the same as having a trust corporation as a deputy, I suppose,
Absolutely.
isn't it?
Yeah.
Kerry's my attorney, and I'm her attorney, because our children are under 18,
Mhm.
we're husband and wife. It makes sense. In 40 years' time, that wouldn't make sense, because she'll be 30, I'll be 80.
She'll always be 30.
She will. So then I'd have to change it and have my children as. But if I had a Nelsons Trust Corporation in 40 years' time, it wouldn't matter because the Trust Corporation hasn't got any older.
Yes,
Um,
it will still exist.
yeah,
Yeah,
yeah.
And a lot of our clients might consider, you know, their children in the first year, but like I mentioned before, the replacement attorney appointment can be just as important, and that could be your professionals.
Have we got another one? Oh, wow.
There's one you haven't done.
Is it?
That one.
You have a
That
lot
one.
of questions, that's a good sign.
Yeah.
People still must be logged
Okay.
in.
Oh my goodness. We were given an interim deputyship for health and welfare, which we haven't discussed. We should do another session just
Yes,
on
that's
health
a
and welfare.
completely
Yeah.
different session.
After doing the application ourselves as parents, our son has appealed against this dole's order, against his dole's order, and we applied for deputyship before he appealed against his dole's. His solicitor has had our deputyship application set aside until the dole's is finished. This has been a year now, and why do we have to wait so long? The judge has joined our deputyship application with the dole's appeal, as our son has refused to do the capacity test. There's a lot going on there.
That's a session in itself.
Yeah.
Yeah.
So there's a deputyship application from family, a dole's application as well from the local authority they'll be going in, and the courts have attached the two together, but the son's refusing to do a capacity assessment, which then means the doles can't go through and the COP 3 can't be completed.
They must have asked for a new assessment, because the assessments would have been done before the deputyship health and welfare application was made. So potentially because son is objecting, they're wanting him reassessed. Would you say
Possibly.
that's
I wonder
right?
whether there was another capacity assessment done for the dolls later.
Yeah,
But again, I
and
see.
he's declining the doles
Yeah,
assessment.
potential instance, and the delay. Unfortunately, the court are very busy, so there's a delay with applications. But I imagine what the court will have to do is say, look, you've got to have a capacity assessment. There's no way around it.
I mean, it's strange that because I got into an argument with a barrister from Essex Chambers on LinkedIn about consent, which is a great thing for two middle-aged white men to be arguing in public. It's about consent, but it was consent about capacity assessments. We weren't arguing, I was just told I was wrong, and he was completely right as well. Somebody had posted about, do you need consent to agree to a capacity assessment? And I said, well, of course you do. You know, you can't do something with somebody without their consent. That's wrong. And the barrister came back and said, well, actually, no, you don't need consent for a capacity assessment. And we had this big discussion, and he's absolutely right. It's a ridiculous idea that you need to have consent to do a capacity assessment, because if I go out to assess somebody's capacity for a will tomorrow, well, I need to make sure they've got capacity to consent to that. So I'd need to go out and do a capacity assessment today on whether they can consent to the assessment tomorrow. If I'm doing an assessment today, then I'll need to do an assessment yesterday to see whether.
Yeah.
Do you know, so one, that becomes absurd, but the other side of it is you get to the point where a doctor says this person hasn't got capacity to consent. I need to do a capacity assessment, but what happens? I know he needs his surgery, and he needs it now, and it all just goes terribly wrong. So Alex Rook-Keane quite clearly stated that actually you don't need to have consent. So in this case, I think from a capacity point of view, okay, he's declining to do the assessment. I think it's a good assessor that assesses him without his consent, potentially, and just does the assessment in a very therapeutic and kind way with him. Speaks to family to identify what his capacity is actually like, and does a very holistic assessment. I can't think of another way of moving that case forward, because if there isn't a capacity assessment done, how can the courts make any decision?
You do sometimes see the judges make an appointment to go and see P themselves.
Yeah.
So I've seen that on cases where it's been done remotely, and the judge will probably be saying, look, if you feel you've got capacity, it's in your best interest to get assessed, because you do your capacity assessment, you've got capacity, all of this goes away, the court protection have no jurisdiction,
And I think that's the thing getting across to people, isn't it? This idea that the court capacity assessments, the courts, the court protection aren't there to say you can't do this. It's about protecting that person, but it's about protecting their rights to do things, not to take things away from them. So yeah, I think I don't know who asked that question. I don't know who's Ria, but yeah, I think it's a difficult situation, but get the assessment done regardless. Abby, we're dealing with a statutory will application. The P's estate is set to pass to siblings via intestacy. I can never say that word. Sister is deputy. P's lost capacity in the 80s by a road traffic accident. 2 siblings have a drug addiction and no contact with P. We are planning to apply to the court for permission not to notify the 2 siblings. How likely do you think it is that the court would dispense with notice not to notify those 2 siblings?
On statutory will applications, it's in the practice direction that you must notify everybody with an interest in the estate that's being, I guess, changed within the body of the statutory will application. So in essence, you must notify everybody who's due to inherit under intestacy rules as a respondent, which is very different than just a notified person. So they receive at the beginning. They get the full application as to what the statutory will is and why you're making this application. Gives them an absolute right to object because they're due that inheritance legally. You're taking away their statutory
And just
right.
because they haven't had contact
Absolutely,
with P,
because
or just because
they've got their own problems, that doesn't necessarily mean they should be disinherited. And the court takes that position very strongly.
See, my social work brain's now going, and I'm thinking, yeah, but if they got that money, that might pay for them to go into rehab, and it could be, just,
or it will be going
because,
on other things.
Yeah, or it could be going on unwise decisions.
Unwise decisions, absolutely. But again, I will personally, from my experience of statutory will applications as well, I think that would be you can apply for the rules to be dispensed and for people not to be notified. But the only time I've really known that to be successful is when, say for example, the person who would be filed as a respondent is actually the abuser to the vulnerable adult, or has caused the harm to the vulnerable adult and is no longer a part of their lives. And though it did end up, in a hearing with a judgment,
and that makes sense. If you were the parent and a sexual abuser of that child, then rightfully so, you shouldn't then be entitled.
The decision wasn't taken lightly by the court, and it was quite clear it's not a precedent. It is more about looking at it for each individual. The general rule is everybody who is to inherit under intestacy is served as a respondent, and you're risking higher costs stepping aside from that. You're risking a hearing being listed to move away from that, which is, statutory will applications are very complicated, and the rules are very different. Would you say anything different to that?
I think the exact same. The only way doesn't mean they're going to object and get an inheritance.
Yeah.
It just means that they're going to be heard by the judges.
I suppose bringing it right back though, I know they've said that they didn't have capacity, lost capacity in the 1980s. That was last week, I think, the 1980s, wasn't it? Yeah.
Well,
sure
that
it was. Yeah. The person might have capacity, and testamentary capacity is far different from the Testamentary Capacity Act, especially now with the changes to the Mental Capacity Act. So I start at the beginning, if you haven't, and make sure that a testamentary capacity assessment's been done recently, which they need to do for statutory will anyway, and life expectancy as well.
Yes.
Yeah. Cool, we've got 1 minute probably by now. So if there is any last 1 minute questions, then throw them through. If we don't get to respond to them, I'll send them over to Stuart and Gemma. God, I don't know where my brain is today, honestly. We were watching Game of Thrones last night, and I've got Alan in my head. One of the characters is called Alan. Weirdest name in Game of Thrones yet. But I know I've got some quick messages for Fumi, our marketing person, or she will shout at me, and there is abuse going on. Next month we've got Nellie on the sofa with Kerry, my attorney, and my wife, and our Director of Operations. Kerry's also a fellow of the Royal Institute of Forensic Anthropologists and holds a master's degree in forensic anthropology, and she's going to be talking about life expectancy reports, which is strange because we were just talking about statutory will, which is life expectancy is required for those. So please do log on to Eventbrite. It is live now, so you can book your tickets free of charge. Con in November. We've got some absolutely fantastic speakers. We've got Paramount Legal talking about the cost course that we mentioned today. We've also got the Star Charity, a local charity, coming to talk as well. And Kerry's going to be talking about life expectancy, and Mandy's going to be talking about communication. And I might have to drop in and talk about financial vulnerability as well, although I'm trying not to. And we've got some other really cool speakers coming along as well. So please go on to Eventbrite and book your tickets for NellieCon. And anything else that I need to mention for me? No, I'm getting an all clear. That's fabulous. Thank you for your time. If you do have any questions, queries or conundrums, send them through and we will try to get them answered by email for you. Thank you for your time.
Great.
Ooh.
We're still there, aren't we, Finn? Just it's all right. This can go into the outtakes.
Yeah.
Well done. Thank you.